But let's bring in our guest for this hour. Joining us now, National Trial Attorney Michael Jaafar. Michael, that was the family court judge there at the end, of course, before Doug Benefield was killed. But the judge that we have actually over the case we're in now, the murder trial, this morning the defense tried to get him to recuse himself because of how he characterized the denial of the stand your ground immunity case. I mean, this seems like a Hail Mary that the defense was trying to throw up on the eve of trial. But your thoughts on where a defense finds this idea of deciding, let's try and go after the judge just because they made a ruling previously against us?
That move by the defense attorney confused me. I've got to imagine it has something to do with that bizarre colloquy that same judge had with Benefield, where he just went on and on and on, I think, for 30 minutes, preparing for a 3850 motion, which is a post-conviction motion. I have to assume it has something to do with that, because not out of vindictiveness, but because I think they think that they're going to have to, they have grounds, they have an opening to, file for a new trial if this goes against them by basically combining the two, his denial of the stand your ground motion along with, his bizarre colloquy. I don't think it's smart. It kind of confused me a little bit, but I have to imagine that has something to do with it. To be quite frank with you, if you ask me in 1,000 trials, how many times do I see an attorney file a motion for the judge to recuse himself the week before the trial? I would probably say 0. Now I have to say 1 out of 1,000 because of this case, but it kind of confused me. But that's the only thing I can imagine as being the impetus behind it.